The broadcast is now starting. All attendees are in listen-only mode.
Hello everybody and welcome to this month's Specifying Practice Group call. Before we get started with today's session on warranties, as you see on the screen, just a few more housekeeping issues for everybody. Reminder that everybody is currently in listen-only mode. That is just to prevent the amount of background noise that typically would happen with a group of this size. At any point, however, if you want to get involved in the session, there are a few ways in which you can do that. Easiest way is to click the little animated hand button on your GoToWebinar panel, which should hopefully be somewhere on your screen right now. Doing so will grab my attention and let me know that you have a comment or a question you'd like to add to the group. I'll probably send you a chat message and just ask if you want to be unmuted to ask it directly, or if you want to type it in so that I can pass it along to David, Lewis, and Robin as we get going. Additionally, if you want, you can just go right into the question and chat box that should also be on your GoToWebinar screen and just simply add your questions and comments as we go. Dave and Lewis are very good about moderating those throughout the session and adding them at logical points within the session. And lastly, for those of you that are on a phone or have a second screen for your computer, feel free to join in on Twitter. Our hashtag is continually going to be CSISPG, all one word there of 6 letters. And I'll try to follow along on that and send your tweets back or input them in for Dave and Lewis to bring up as we go through the session. So with that, I do want to hand it over to Dave and Lewis to also introduce our guest speaker today, Robin, and get going with today's session. Finally, as a reminder for everyone, today's session is recorded and will be made available on the YouTube channel at youtube.com/CSIConstruction. That recording will probably be up on Monday after the holiday weekend. So look for it then if you have any questions or if you get disconnected and want to catch the rest of the session. With that, Dave and Lewis, over to you to get started with today's session.
Well, thank you, Matt. This is Dave, and to everyone's surprise, perhaps, I'm actually in the office today, not out gallivanting around, stealing Wi-Fi, as Matt likes to think I am. Coming to you from South Jersey, and Lewis?
This is Lewis Metcalf in downtown Nashville, Tennessee, and it's kind of gloomy and rainy today, but looks like going to be a pleasant weekend. And David, will you introduce our designated sacrificial lamb, guest speaker, Miss Robin Schneider?
I'd be happy to. Robin is joining us today from Phoenix. Robin's an independent specifier and an attorney. So we thought it might be a good idea to have her join us and be able to talk about warranties, seeing as how it's more than just a specification issue, that there are some actual legal implications. So Robin, you want to tell us a little bit about yourself?
Sure. So as David mentioned, I'm out here in Phoenix where it is unusually humid today and muggy. Independent specifier, I've been doing this about 24 years, had my firm 14 years. A few years ago, I passed the California bar exam, so I'm currently licensed to practice in California. Because at the moment I live in Arizona, I'm not practicing law, but try to keep my toes into the industry through construction law forums and events. So while I will throw my 2 cents in here on the warranty issue, I do have to qualify it's not legal advice. It's just opinion. I gotta say that.
As every attorney would expect you to. Thank you for the disclaimer, Robin.
Gotta say it.
Yeah, gotta say it. Okay, so thanks for joining us today. And Robin and I have known each other for quite a while, it seems, but have never really been together on the practice group, so I'm looking forward to this. So Lewis, this warranty issue was one of your thoughts, so why don't you explain overall what's the rationale and what we're hoping to get out of today?
Well, we thought, for one thing, that this made kind of an interesting follow-up to last month's session on installer and manufacturer qualifications and contractor qualifications, because they're kind of related, because we're all looking for quality for our clients. What we want is something that's built right and it's made out of products that have a good service life and good performance, that will be a good value for our clients. And warranties, as you can see from the title that we came up with, can sometimes be very beneficial, that if you do have a disaster failure, there's a method of recovering from it. But on the other hand, some warranties are just there to try to sell product, and they are not really meaningful, and there's no real help or benefit to the client. So we thought we'd go through and kind of talk about warranties in general and try to focus in on a few of the practical ideas about what to look for in warranties and how to deal with them.
Okay, so why don't we do this, Matt? Why don't we start with the first poll question and just find out everybody's attitude towards warranties themselves. And this is from your point of view and your client's point of view. Do your clients actually use warranties as a measure of quality?
And do they request warranties for certain things, or remind you, don't forget the warranty for X or whatever?
Okay, so we have over half of our listeners who are weighing in at this point. So Matt, you want to share the poll? Okay, so if you're showing it, Matt, I'm not seeing it, but that's okay. I see that.
That's showing up.
Okay, well, I don't see it.
It's for here.
Okay.
Okay, well, only 11% say that they are not getting any feedback from their, or any direction from their client about the need for warranties, or that that's a indicator of product or system quality.
Okay, and Louis, we gave them a way out with maybe. What the heck is maybe?
It depends upon what the warranty is.
Okay.
Which brings us to our next polling question.
We should do the next one? Okay, go ahead.
Yes.
All right.
So now we're asking you, master specifiers, do you consider warranties to be a measure of product or system quality?
I would think that this one might be a different answer than the last. What do you think, Louis?
Actually, it's coming out the same. Almost identical numbers. Almost identical.
Oh, that's actually disappointing.
They're a little higher on the no. We have 15% instead of 11% are saying no completely. But the rest of, and we have about a third saying in general, yes, it is, and 52% saying it depends. And that's a good answer, really, because one of the takeaways from this session, I hope, will be to keep your eyes open and read the fine print.
Yep. Okay, so let's go ahead and dive into this. So one of the very first considerations that we have to have is just what is it that we are specifying. And I've got to tell you that some of the architects I'm dealing with, some of my clients, really don't understand that there is a difference between a guarantee and a warranty. They tend to use the terms interchangeably. And it usually takes some extended discussion to try to get them to understand. So I came up with these, and I'm going to get Robin to chime in on this. This was my way of trying to explain this in the very shortest terms. So a guarantee always involves a third party that's assuming an obligation, where a warranty is just a promise that something that you've said is actually true.
Right.
And in the case of a written warranty, it's actually a form of a contract.
Okay, Robin, you started to chime in, so.
Yep. Well, and part of the confusion, David, is that if you do a little Googling on guarantee versus warranty, even in the construction industry, you'll come up with a myriad of different explanations. So that's what I think even the industry itself is a little confused. But your explanations there are pretty much right on. So for a guarantee, you're talking about having a third-party agreement where the third party, and whether that's a surety or even you, like you said, co-signing on somebody else's loan, that third party is making a guarantee that in the case of a default or a problem, you will step up and take care of that obligation. So if your son defaults on their car loan, you'll pay the bill.
He better not.
And that's why you get things like the sureties and everything that are basically guaranteeing the performance of the second party. So that's the guarantee. Now you will see the term guarantee. Go on.
An example of that in the construction field is that at one time back in the 50s and 60s, and to a certain extent into the 70s, many roofing for roofing and commercial roof installations, people specified a roof bond rather than a warranty as such. And so the roofing manufacturers had to come up with an actual, a bonding agency that would cover them for the repairs to the roof during a certain warranty period.
Right.
But those are kind of fallen out of general use these days.
Yeah, but bonds are a unique instrument in and of themselves because they're not truly a guarantee, because the bonding agent still will attempt to collect from the person who is being bonded. So it's not quite the same. So Robin, you were starting to explain more detail about the warranty.
So a warranty is going to be between two parties, and typically you think of it as between a seller of goods, but in this case it could also be we'll call them a builder of goods, the contractor who is building the building, and the purchaser, which in this case would typically be the owner. And it's any type of an assurance on which the buyer can rely. And as I think Lewis mentioned, you can have written warranties, and I think we're going to get to that, but you can also have implied warranties, which are not necessarily written. But it's any type of an insurance that the buyer of a good or the owner of a building can rely upon as being true. And if it doesn't, then you have a breach of warranty potential.
Right, and one of the important aspects of warranty is that there's always some limitation to the warranty. And that is really the key to understanding what those limitations are.
Correct. And I think we're getting into that.
And we'll get into that a little bit further.
Okay.
Oh, yes. One thing before we leave the slide is please keep in mind that the verb form is warrant. I'm a frustrated English major, and it's fingernails on the black chalkboard time when people say, oh, the contractor said he would warranty this or warranty that. Warrant. Okay.
Leave it to a specifier to pick that out.
I'm pathetic.
Okay, so one of the things that in even considering whether or not to include a warranty in a construction specification is, really, what is the risk? What might the owner be assuming, and then what is the cost of actually providing that warranty? I am a very strong proponent of looking at products and making product selections with a lot of due diligence, trying to find what might be appropriate for the project, trying to find something that will be durable enough that it would suffice to meet the owner's expectations. But the owner is really the one that has to identify what is his risk. How long is he actually going to own this building? Whether or not he can afford a failure, and whether or not the building is, or whatever the system might be, if it might affect his mission critical operations. For instance, a data center. You certainly want one to have a roof leak over a data center and take out the all of the equipment that's actually providing the revenue for the owner, and because the downtime and the replacement cost would just be exorbitant. So it's a risk assessment, really, that the owner has got to go through and identify what he's willing to accept and what he is not, and then what he is willing to pay to avoid that risk.
Well,
On
David,
the other hand, I've done some projects.
Can I just mention real quick,
for,
Louis?
oh, sure. I'm
sorry.
sorry.
I just want to mention, because David, one thing you're mentioning, though, is having a warranty is not necessarily going to prevent that roof from leaking.
Correct.
Data center. So that's I think where some of the false sense of security comes in.
Right, and that's why I'm saying trying to find the right product, the right system is something that may be more important than even trying to ask for a warranty.
Right, exactly. Sorry, go on, Louis.
I was going to say that having done some projects for developers who were going to flip the building, sell it right away, they weren't interested in having a long-term roof, and because good warranties, as it says here, are not free, especially roof warranties, there's actually a dollar amount. And so I've done projects for some developers where they only contracted for a 10-year roof warranty rather than the typical 20 or 25-year warranty, because they knew they were going to sell the building right away and they didn't care about what the next guy's problems are.
And Louis, we have our first comment, and don't you know it's from Sheldon? Do you? I love it, Sheldon. Thank you. Sheldon says, being right is not pathetic.
Thank you for that support, Sheldon.
we like to think that
yes.
we're keeping the
I was telling David the old joke, you know, about the fellow that is dealing with kind of a sharper who's handling some of his financial affairs, and he says, well, so if you were my broker, what does that make me? And the sharper says, well, if I'm the broker, you are the brokey.
Yes.
Is that
okay?
And
we'll
just how does that apply to warranties, Louis? There's got to be an analogy.
Well, it's that EE business of the end. That's the person who receives the warranty, as opposed to the warrantor who warrants.
Okay. So.
And of course, one of the questions is, does the warrantor have deep pockets? You know, we get advertisements all the time for brand new products that have only been on the market for a year or less, and all of a sudden they're offering 20-year warranties, and it's some company that you've never heard of. And do they have the resources that is your failure? Right now, we have a project going up with a curtain wall system that I've never been there. Pathetic. I mean, it's like it's amateurish. If they a major failure on this 16-story building, but the owner got a nice price. But if there's a major problem, will they be able to cough up the dough to replace or fix a bunch of windows?
Okay. And in doing some research for today's presentation too, I was out searching some warranties that I could find on the internet, and I found one for a roofing warranty, and it goes to this last point, is just what maintenance and reporting must the owner or the warranty do in order to affect the warranty or keep it in effect. The roof warranty I found goes through many of the normal sort of exclusions, you know, things like acts of nature and acts of God and all this that no one can control. But it goes on to say that they also must abide by the care and maintenance instructions that are attached to the warranty. Well, the downloadable warranty doesn't have those care and maintenance instructions attached. And I went searching the website to try to find them, and they were nowhere to be found, at least not easily found. So here is, a warranty referencing another document that actually has importance to the warranty, but it's not readily available even for a specifier to go and look to see what the requirements are, to know whatever the owner may be obligated to provide. And if you think about this sort of an analogy, when you buy a new automobile, it comes typically with some sort of a warranty, but if you actually read the warranty, you have to abide by the maintenance routine that's laid out in the owner's manual, which means you're going to be visiting the dealership every 3 months or every 3,000 miles, and you have a whole schedule of maintenance that you have to perform, and you probably have to have a record of that maintenance if you actually want to make a warranty claim later. So, Louis, last car you bought, do you have all those records? I know I don't. In my car, I'm still still under the loan payment.
Well, actually, that brings up another issue: is the warranty transferable? Because the car that I drive, I bought used, but fortunately, the warranty was in fact transferable to me, and so it's registered in my name, and I have all my service done at my local Goodyear place, and they have everything on computer, so if I ever have a problem, they can cough it up and demonstrate that I was in there on a regular basis. We do have a question or a comment, a question from Scott Anderton, and perhaps Robin would like to tackle this one. Is there a correlation between risk, cost, and the amount of unreadable fine print in the warranty document?
Yes. Most likely there is.
And that's a clear answer. That's a clear and concise and correct answer.
You better believe it.
The primary impetus for a manufacturer to write a warranty is because an express warranty always governs over an implied warranty. And as Robin's already said, mentioned, there are implied warranties that if you go to a store and you buy, there's a warranty on a pack of gum, chewing gum. There's an implied warranty under the Uniform Commercial Code that it is fitness for purpose and that it's not contaminated with, something that would harm you or whatever. So there is and you open up a stick of gum and you find a dead insect in there, you can make a claim on that. Well, the point about the express warranties is that they are a method of the manufacturer, and this is not necessarily nefarious, trying to limit their exposure to what they can control. So they are trying to establish some level of equity in terms of if they're not installing the product and it can go badly wrong by bad installation, they don't want to be they're going to disavow any coverage for the installation itself. So that's it's to their advantage to spell out exactly. And for example, even in roofing, since we've been talking a lot about that, most roofing warranties are limited to certain wind speeds, and if you get above a certain wind speed, your warranty may not apply, and you may have to try to talk to FEMA instead.
Right, but on an express warranty, that's something a specifier can actually help to control, because if we're writing it into project specifications, it becomes a condition of the contract and is therefore an express warranty. And one of the major differences in the warranty is that full warranties and limited warranties, and the distinction is really coming out of UCC, because UCC, the Uniform Commercial Code, establishes no time limit for warranties, which compels every manufacturer to then issue a limited warranty that specifies a time. So virtually every warranty that's available is some form of limited warranty. So I guess I would wonder whether or not at that point, if you know that all the warranties are virtually limited by some means or another, whether it's time primarily or it's some other circumstance like acts of God, whether or not these then do become a value to the owner, or whether or not we ought to be looking for other ways to determine product and system quality. So even we'll stick with the roofing analogy, even a full, what we might consider a full warranty on a roof system, a no dollar limit, 20-year, 30-year, whatever you're able to get, is still a limited warranty because of the time. It's not truly a full warranty.
The closest we come to a full warranty is, I suppose, that most manufacturers of flush wood doors will warrant the door for the life of the building.
And as we get further along, I think we're going to start talking about things like Statute of Limitations and Statute of Repose, which layer in a statutory limitation on even full warranties. So even a full warranty is not going to be a full warranty, a timeless warranty, I should say.
Okay, thanks, Robin. Anything else on this one that you'd like to add, Lewis, before we move on?
No, I think we can. All right. We can go on again because again we talked. So now we come to the contractor's general warranty, and those of you who've participated in teaching the warranty chapter in the CDT know that there's in the crowd, because all of a sudden they start writing furiously and copiously taking notes, because when they find out that the contractor's general warranty is not limited to 1 year, this is often a surprise even to people who've been in the business for some time. So under the A201 general conditions, which is fairly typical, it says that products are going to be new and good quality and so forth, unless otherwise permitted or required by the contract documents, where sometimes you may want to use used products like used brick or whatever. Note that there is no specified period. That means that the contractor's warranty is governed by the Statute of Repose, which we will explain, or endeavor to. We'll get Robin to explain here in a minute or two. It is that if you've got a hotel with 1,000 rooms in it and there's one screw missing from one hinge, the contractors come out on the site and replace that screw. And then the warranty also includes installation as well as defective products, and it can include performance, especially if the specifications tell the contractor to provide construction that is supposed to meet certain performance criteria.
And this warranty is also limited because it excludes the owner's maintenance and operation that may cause damage.
Yes.
Because the contractor is not responsible for that.
Right, and something that is improper operation, insufficient maintenance, and even normal wear and tear. I mean, we've had some owners come in and want to make a warranty claim for what was just really just normal wear and tear. Hey, you're going to have to replace the brakes on your brand new car in 50 or 60,000 miles. Just live with it.
Okay, so Lewis, did you want Robin to chime in here on Statute of Repose?
Well, we have a slide for that.
Okay.
There's a slide for that.
All right. Here you go, Rob.
And here it is. All right. You want me to chime in here?
Absolutely.
Sure.
Because these are some slightly confusing, and they're interrelated. The statute of repose, as the slide says, defines a absolute time frame by which a claim can be made, and it does vary from state to state. And it's usually triggered by an event. And in construction, the event would be usually substantial completion, or some nuance thereof. But so once the owner takes possession of the building, that's when the clock starts ticking for your statute of repose. And let's just say hypothetically, in Arizona, I think it's 8 years, I believe, but it's different in every state. That essentially defines your contractor's warranty term that we discussed in the prior slide. After, at 9 years, the owner essentially cannot bring a warranty claim for damages, which we'll get into a little bit later too. The statute of limitations defines the period of time by which a claim has to be made after you discover or should have discovered or reasonably discovered a defect. So the best way to kind of say that is if I take over my building and my statute of repose is 8 years, and in year 2 I discover my leaking roof, and my statute of limitations is 4 years, I have 4 years to make that claim because I'm still within that 8-year statute of repose time frame. Let's say in year 7 I discover a leaking roof, and I want to wait until year 9 or 10 because I'm still within that 4-year statute of limitations period. Well, now I've exceeded my statute of repose, that original 8-year limitation. I can't file a warranty claim for damages at that point because I'm past my 8 years statute of repose. It's one of those things that's easy to see on a time chart but hard to explain.
So what I think you just said.
The AIA publishes.
Go ahead, Louis.
Yes.
Yes.
I was going to say that the AIA publishes a document that is a synopsis of all the statutes of repose in different states, and so you don't need to. One of our questionnaires here, or one of our audience, ask where would you find that kind of thing in the state statutes. Actually, there are places where you could, like I say, the AIA has a document, and there are probably some places online where you could find out what that information is for your local state. In Tennessee,
so I actually have a PDF if anybody wants. I have one on my files if anybody really
wonderful.
wants to just email me.
In Tennessee, we have a very short statute of repose, only 4 years. And the statute does include a definition of what substantial completion is in the event that there's not a written instrument and an agreement on the date of statute of when the substantial completion is. And I think some of the other states, their statutes do also define that starting point. And so Kelly Gray asks, is the statute of repose different from the typical overall project warranty? What it does is it defines the period of that overall general warranty.
Right, and it also defines, as Robin was saying, the time limit in which you can even file a claim depending upon when the defective work is discovered.
Right. So then Scott brings up an issue of that obviously we're going to specify some warranties that extend beyond the statute of repose, because a 20 or 25 year roof warranty is going to extend beyond, well beyond even the most draconian state statute of repose. And by the way, most of those statutes of repose have to do with both design and construction. So in Tennessee, Wins is off the hook in 4 years.
So if you want to know when you can start throwing things away, it's good to know your statute of repose.
And it's still may have to go in and make that argument in the court. But Tommy Smith points out that Well, we'll talk about this later, Tommy. We'll get that later.
Louis, do you want me to address the comment about the 20-year warranty in the statute of repose?
Sure.
So, and this is where it starts to get a little, well, I guess continues to get a little confusing. So, basically, the statute of repose defines a time by which you can submit a claim for any damages. So, let's say in Arizona, after 8 years, you've got a 20-year roofing warranty. It starts to leak in year 15. At that point, you can still ask the contractor to replace the roof, under the warranty. If they say no, your suit that you would file would be for what's called specific performance, which is basically to force them to replace the roof. But you wouldn't be able to collect any damages on top of that, like the data center that Dave was mentioning earlier or anything like that. So you would still have some remedies under the law after the statute of repose, but there are different remedies available to you. So it's not a worthless warranty, but yeah. Go on.
And your primary protection is from the roofing manufacturer who issued that warranty. Now, there is always the problem that I had a job many years ago back in the late 80s where we specified a premium 4-ply built-up roof, no dollar limit warranty, and when the project was done, the roofer said, oh, by the way, I'm not authorized by the manufacturer, which I think was Johns Mansville, to do warranted installations. And the GC all of a sudden realized he was on the hook for the next 20 years for that roof. And so he quickly negotiated a financial deal with the owner to get out from underneath that warranty obligation, because he had contracted, you see, by signing the contract documents in the specifications. If it requires a 20-year warranty, somebody had to provide that. And if the manufacturer wouldn't do it, then the GC was on the hook for that.
Mm-hmm. We have an excellent question from Paul Zanetti. And Robin, this one may be specific for you. So he has a question about the full system warranty. And now I'm going to have to just scroll up because I just lost the top end of the message. Okay, more and more today we've had to design build in Canada. In Canada, our wind uplift standards are all over the map. Now, if the specification asks to design for a 100-mile-an-hour wind load and a manufacturer provides you with a hybrid system that was only partially tested, in the event of a wind uplift disaster prior to the warranty expiring, who would carry most of the liability in this case, the consultant or the manufacturer? So I think this is really about enforcing the documents, because you have a total system warranty specified, but apparently this manufacturer might only be offering component warranties or not necessarily a fully tested system.
Well, and that, I mean, obviously we can't say, who would be liable without, months and months of court cases and high legal bills. But you're talking about something where, in theory, hopefully the contractor had submitted a roofing assembly, and would it be reasonable that the design professional reviewing it would see that it was a hybrid assembly, or did it somehow imply that it had been tested as an assembly and met the specifications?
And of course,
that's the type of thing they'd look at.
Was it an unauthorized substitution? Which brings us to a point that friend Tommy Smith of Memphis brings up, is that there's no statute of limitation on fraud. So if something was fraudulently provided by the GC, the statute of repose is no protection for the GC.
Right, and yeah, exactly. I mean, and this is the statute of repose we're talking about is breach of warranty and all the various, but if they're intentionally misrepresenting something, then you could get into a fraud claim.
Yes, they just bait and switch. They tell you you're going to put something in, they put in something cheaper.
Right.
David, tell us about how Master Spec handles warranties.
Yeah, Master Spec, you you need to be careful if you're using Master Spec, because Master Spec relies on Division 1 like most of us do. And Master Spec defines some of these warranty conditions in Division 1. This is extracted out of the Master Spec standard. And notice they have two different kinds of warranties that they're talking about. In essence, they define warranty in paragraph A, and then they talk about special warranties in paragraph B. And the attitude in Master Spec is that a special warranty is something that the specifier is asking for that is project specific beyond what they might the manufacturer may offer in a standard warranty. And if you look at the various individual technical sections, you will see the distinction between the manufacturer's standard warranty and a special warranty flow through into the technical section. So you have to be aware of how you're editing each one of these sections if you're using Master Spec. Okay, the other one that Lewis was so good to put in bold red, I'm sure this is a subject near and dear to his heart, so he's going to explain this one.
Some of the Master Spec sections, especially roofing, but there are some other product types, have a written installer warranty at the end of this section. And let's go to that example.
Will there be a test later? Are you going to make all of our audience actually read this?
No. Oops, that's not it.
Oh, okay. Where did you put the sample?
Is it out of sequence?
There we go.
Okay. And we were talking about this before the presentation started, and Robin, I think, will back me up and maybe want to say a few words, but it's one thing for us to say, I want a 20-year limit, no dollar, it'll provide for complete replacement if, and blow off up to us design wind conditions, whether it's 90 miles an hour, 100 miles an hour, whatever. And we can establish the criteria for the warranty, but it's quite another thing to actually issue terms and conditions of this contractual obligation between third parties, in this case the roofing installer and the owner, especially since by having a separate installer warranty as opposed to the manufacturer's warranty, the terms and conditions in this installer warranty may be different from those in the contractual relationship between the installer and the roofing manufacturer. Manufacturers are generally only going to warrant something with a company that they know and trust, that they are satisfied that they are financially responsible and they do a good job, and there will be a legal agreement between them, and the manufacturer actually has to issue an authorization to proceed with a warranted installation. They may want to see some of the project specifications and details, and one of the things I always do is ask for a copy of that letter so I can make sure up front that the roof will at least be theoretically warrantable once before it gets started. And so Master Spec has these written things establishing terms and conditions, and my concern is that we as architects and engineers are not licensed to practice law, and if there was a major failure and if there were some problems and when the dust settled the owner didn't get what they wanted, it seems to me like they could have a comeback on the AE by saying, you guys wrote these terms and conditions that did not provide the protection I need. You were practicing law without a license, therefore cough up X $1,000.
I think that's a strong possibility there, Lewis. Was that Lewis? Sorry, or David?
Yes. Mm-hmm.
Okay. one of the definitions of practicing law is preparing documents that secure legal rights for a specific person. And when you start doing these types of warranties, typically our specifications are addressed to the contractor, and the contractor is bidding them as part of his contract with the owner. When you start inserting these installer warranties, now you're trying to set up a contract between the owner and the installer, who really aren't the intended audience of our specifications. And so I think there's a strong argument that by doing that, you are practicing law without a license, which is one point. And second point, like you said, is you may be conflicting with the contract that the roofing manufacturer already has with that installer. So I don't like them. I agree with you. I don't like them.
Yeah, I delete them all.
Right, and in the case of roofing, as our continuing analogy, that we're often specifying total system warranties anyhow, so we're buying the installation warranty from the manufacturer, and whether he secures it from the original installer or some other installer is his business, not necessarily the specifiers.
And just for general knowledge, typically roofing manufacturers will expect the installer to be responsible for defects in installation for the first 3 years or so, and then after that time the manufacturer takes up the responsibility.
Right. Now, let me see if I can get back to where we were, right?
Right. And while you're doing that, Scott Brumbach asks, does an implied warranty ever supersede a written warranty during the coverage time frame or after? And the answer to that is basically no. That's why an express written warranty always trumps an implied warranty under the Uniform Commercial Code or other industry standard. So in addition to the confusion about the 1 year typical warranty on construction, partly arises from the contractual obligation for a correction of work period that is established here in paragraph 2.2 of the A201 general conditions. And now residential construction is a little bit different. If you ask somebody to come in and put in a new bathroom or a new kitchen for you, he's probably going to have a printed form contract, and that printed form contract will say 1 year for the warranty period. But we're talking about the commercial construction that's governed by the AIA general conditions. That's not the case. What this means is that during that first year, there's kind of a presumption that if the owner makes a claim, it is in fact defective, and the burden of proof is on the contractor to say that no, it's except it was installed correctly and it is acceptable. After that period, the burden of proof shifts to the owner to demonstrate that the work was defective, and that's kind of a bit of a simplification, but that's kind of a rule of thumb. But I don't know how much of this you can read, but in subparagraph 12.2.5, it says that nothing in this section 12.2 is meant to limit the other obligations the contractor has under the contract documents, namely the general warranty specified in paragraph or section 3.5. So that's where the confusion comes from. And one of the things that is often absent in owner-written general conditions is an understanding of the distinction between the contractor's general warranty and the correction of work period. For example, a couple of years ago, we were doing a project for the local electric company, and I pointed out to them that under their general conditions, they only had a 1 year warranty. It specifically said that. And I explained to them that that was not usual and customary. The staff lawyer went away and thought about it for a while, came back at the next meeting and said, by gum, you're right. and they actually rewrote their general conditions to sound more like the AIA, so that the length of the contractor's general warranty would be governed by the statute of repose.
Okay. So one of the things too, going back to master spec as an example, and we talked a little bit about the roofing warranty, the installer warranty, and this is what's really going to that. Master spec, when it includes requirements for special warranties, also tends to include an informational submittal that requires the sample warranty to be submitted, presumably for the architect to review the warranty, and presumably also, since it's a legal document, to pass that warranty on to the owner and the owner's counsel for their review and acceptance of the terms and conditions for the warranty. This is, if any of the specifiers in our audience probably know, that trying to get owner's counsel to comment even on the supplementary conditions or the conditions of the contract is problematic enough. Trying to get them to comment in a timely fashion on a sample warranty is probably next to impossible.
The phrase I came up with is hopelessly naive.
That's probably a good way to put it. So if we're asking for the sample warranties after award of contract and after the contractor awards all of the subcontracts and purchase orders, are we really in a position where we can affect any changes to those sample warranties? If we do ask for a change, it's probably going to result in a change order.
A large, costly change order that will also delay the project.
Perhaps. So requiring these sample warranties, again, could be problematic if you're expecting project-specific language in the warranty. And it may be something, I'm thinking about it, if it's critical to the project, it may be something that you want to ask as part of the bidding response that you could evaluate and then negotiate an adequate fee to cover a warranty before you actually sign a contract. So
we need to kind of
there's your question.
And that's why we had the sample out of sequence. We departed from our sequence. So I think we've answered that, is that basically no, we can specify the criteria for a warranty, but we don't want to get into writing terms and conditions.
Well, unless we call Robin to consult on the project and then she can write it for us. What do you think, Robin?
That sounds good to me.
Only in California.
Right. But even then, it's probably, again, you're setting up contractual relationships that we really have no business setting up in what we do.
Okay, Lewis, I think we had one more poll, and if we want to do that, we probably ought to get that in now.
Yes, let's do that now.
Can you help us out? So with all the discussion about specifying warranties, from your own experience, have you actually taken advantage of any warranty or know of your clients that actually have?
Yeah, how often are they invoked? We all read stories about these huge payouts, but
and those of you that are answering that you actually have, it would be really great if you could add some comments as to the kinds of circumstances perhaps, or the kinds of claims that you were actually collecting. Okay, so nearly half are saying you're either not aware or you haven't seen any major warranty claims, And that's pretty much, I think, where I expected to see it.
Yes, because even roof warranties are, of course, probably the most common one that get invoked, but many times that damage happens 10 years after construction, and we're busy working on another project, and the owner doesn't even call us in to help, so we don't even know about it.
So
we had fully a third of us, our audience, have had 1 to 5 warranty remedies or claims put forth. So
yeah,
would someone volunteer to tell us about one of those, especially if it was something maybe other than roofing, although I don't want to forbid that.
Because we all know about some of the problems with roofing. So while we're waiting for some folks to chime in on those comments, let's just talk about some of the owner requirements under warranty conditions. We mentioned some before. The owner's really got to take care of whatever the product is. If there's published maintenance instructions and care instructions, that they've got to follow it. They've got to have that documented proof that they've taken care of the product. If it's sticking again with the roof, if it requires an annual inspection, they've got to get a roofer out there, do the inspection, document the inspection's been done, and take care that the documentation is preserved. If there have to be minor repairs as they go along, to make sure that they're done in accordance with the warranty conditions, probably by the original installer, and document the result of those repairs. One of the things that is really important is if there is a claim to be made under a warranty, there are always required provisions that the manufacturer must be given notice, and the notice has to be filed in accordance with the instructions. And if you don't follow the instructions, the warranty may not be in effect.
May not be enforceable. Yeah.
Right. So as specifiers, we understand, I think, about the instructions and following procedures, but owners may not.
And one of the last thing under the owner requirements is that sometimes owners have to, ideally all the warranty clocks start at on the same date, namely the date of the substantial completion. But on very large projects, that may not be feasible, especially think about the manufacturers of the HVAC equipment that gets turned on a year or even 2 or 2.5 years before substantial completion. And so to make things reasonably fair and equitable, especially on fast-track construction of very, very large projects, the owner may have to manage multiple start dates. We had a couple of comments come in. Scott Anderton shares a story that about, let's see, let me get back up to it. A plasticizer being left out of the asphalt that was in the shingle, and the manufacturer fell all over himself, he says, to make things right. And that's true. I mean, you know, manufacturers want to limit their liability, but on the other hand, most of them, I think, are reputable, and if they had a quality defect, they will in fact replace it. I had a glass manufacturer, although they kept swearing up and down that the glass was fine, they did in fact replace 100 lights that were 6 by 6 inside of insulating glass that we thought did not meet our specifications. Paul Zanet says the manufacturer, will usually cough up if it's not a big dollar cost. They'll do the repairs themselves, but if it's larger dollars, it may have to go to a claim or lawsuit. And Marty mentions.
Yeah, it's interesting. We're getting a good variety of product experts that have been involved in these warranties. Because like you said, they're talked about roofs so far, but the insulating glass and as a failure, and we had some laminated flooring as a failure. So I mean, it's a good cross section that we're seeing. It's not all just building envelope. There's some finishes involved.
Right. Well, we're about out of time, and unfortunately, we kind of didn't get to talking about some of the more questionable types of warranties where the actual payoff is just a brand new bucket of gunk that you were expected to install yourself or somebody else is, if you can prove that the product was in fact defective. And some of you may recognize that I'm talking about EIFS, everybody's favorite construction product when I'm talking about that. But we appreciate everybody sitting in for this event. We thank Robin very much for being our special guest, and maybe we'll get her back again next year.
Or
again,
sooner.
I remind our audience that these are, David and I regard these as being your sessions, and so if there's something of concern to you that you would like us to explore or discuss, please, please, please let us know. Keep those large cards and letters coming in. And some of you are more sophisticated, might use email. And some of the questions we didn't get to, if you want to forward those to Matt, he will forward them to David and Robin and me, and we'll try to get some kind of answer back to you. So thanks, everyone.
Thank you, Louis, and a special thanks to you, Robin, for joining us. Really appreciated the input and the different perspective rather than just a specifier, also hearing from you as an attorney, even though it was not legal advice.
Gotta keep saying that.
I thought I would help you out, but thank you very much for joining, and hope you do come back and help us out again.
All right, my pleasure. Thanks for inviting me, and everybody have a fantastic and safe holiday weekend.
Right. So join us again next month. It'll be August. We're late in the time period, so we'll be August 6th, first Thursday at 3 o'clock Eastern. Hope to see you all then.
All right. Thank you, everybody. At this point, you may just